I want to welcome our viewers to Kennesaw Happenings. We have a special person, not in the studio, but right around the corner. Joy was referred by a person, Trent, and so we want to talk to her because as seniors, we get at a stage where we want to know what our options are. So I want you to meet Joy. Joy, just introduce yourself, who you are, your business, and who you serve, and then we'll talk about some things.
You bet. I'm Joy Green-Armstrong, and my office is located here in Kennesaw. Mm-hmm. And I serve the general Cobb County, Cherokee County area. If I have a senior that is not able to drive and they live just a bit outside of the area, I don't have a problem with going to them. And in fact, I've done that. I'm married. I'm married longer than I'd like to say because that'll date me. I'm a mother of 2 adult children, and I'm a grandmother of 4.
Awesome.
I've been licensed for more than 25 years, and I'm licensed in multiple jurisdictions, including Alaska, licensed here in Georgia, of course, United States Supreme Court, and in the Federal District Court in California. I practice both as a litigator and as a transactional attorney for one of the largest banks in the state of Alaska, where I oversaw $3.5 billion in assets, as well as trust and estates. Being an estate attorney is a joy.
Awesome. Well, I know when you say estate, because, when you get a little later in life, you're trying to plan and protect. You don't want unnecessary funds to go, to people that maybe don't spend it the way your family spends it. So what would you say, like, for a senior that's, thinking about, what do I do for the next generation? How can you help us understand the importance of estate planning?
One of the first things I'll say is that a lot of people think that estate planning is only for the rich, and it's not. Mm-hmm. Estate planning is exactly what you said, Pete, and that is you're planning for your future, but you're also planning for your family's future. Estate planning doesn't mean just when you pass away. Estate planning is making sure that you continue to live the way you want to live while you're here. So I'll start at the beginning. One of the first things is that a lot of elderly clients, they want to protect their assets, and there's lots of ways of protecting their assets. If you plan ahead, then you would be able, let's say, to put your assets, your home, any kind of investments that you have in an irrevocable trust. But putting your assets in an irrevocable trust means that you do relinquish your control over your assets at that point. While you may be able to stay in your home and your assets would be protected from any government entity coming to get them if you ever need to get Medicaid, there's also ways of protecting assets without giving up and relinquishing all of your rights. One of the other things about putting your assets in an irrevocable trust would be there is a 5-year look back period. So let's say you decide you do want to go that route and you put your assets in an irrevocable trust to protect it from the if you ever needed Medicaid. And Medicaid in Georgia means not that you can select what adult facility you go to. Medicaid only covers nursing homes, but the government will look back 5 years to see when those assets were put in that irrevocable trust. If it appears that those assets were put in there within that 5-year period, and if it appears as though you still may have some control over your assets, then they will go ahead and recoup any money that has been paid, right, for your care, from those assets. So you're really not protecting them. What is estate planning then as it pertains to while you're living? There's other ways. One of the first things I want to talk about before I get into other types of trust are the foundation documents that a senior and everyone really needs to have in place, and things they need to think about when they do put those in place. The first thing, a healthcare directive. Some people have called them durable powers of attorney for healthcare. What is that document? That document permits an individual to choose who they want to speak for them in the event that they become incapacitated if they can't speak for themselves. What happens if you end up in the hospital? And what happens if you can't speak for yourself? You want to name someone that you trust, that will not be afraid to communicate with the doctor and even question a line of treatment. That's what a healthcare directive does. And so that agent would work for you on your behalf. If you can't speak, of course, then they would direct it. You would have more than one agent. That agent should be someone close by. If you don't have family close by, make sure that the person you select is someone that is going to be reachable by phone. Oftentimes, the hospital or healthcare provider will reach out to someone in an emergency by phone. And as long as your healthcare directive is where they can see it, then they will talk to them and they will go ahead and make a course of action for your treatment on that person talking with them. Now, I just said something about as long as they can see your healthcare directive. What I'd like to say to the listeners this morning is this. When a healthcare directive is drafted up, they should make a copy for their physician. And if there's a medical facility that they would go to, Wellstar, Emory, Northside, they should take a copy of that fully executed document, meaning it's been witnessed, it's been signed, and they should take it and have it scanned into the administrative system at the hospital. Because what happens if you can't speak when they bring you in by ambulance? When they put your name in the system, that's going to pop up because it's part of their administrative records, right? So that's the first thing. The second thing is this. If you, let's say you don't have one, then what happens is what's called a living probate. The hospital, generally through the social worker at the hospital, will have to go to the probate court. And the probate court has a list of individuals that you may not know, you may know. It could be a family member whose name is presented to the court, but it's not you that makes the decision for who's going to be speaking for you. It's going to be the probate court, right? And while you might have a relative that you love dearly and they love you, they may not be the best one to speak up for you medically. So let's make sure that that document is in place. That's your healthcare directive. Now, what goes along with that? What goes along with that is the HIPAA. It's the HIPAA form is a federal document which permits your agent, and it could be someone that's very different than the one that you placed on your healthcare directive, to be able to obtain your medical records. What happens if the medical treatment that's being provided for you, you need a second opinion? And I advise all of my clients, if a doctor says that they need certain type of treatment and it's not an emergency that needs to be done immediately, that their families respectfully say to the doctor, I hear what you're saying, but I'd like to get another opinion, right? What happens if they want then to move you to another facility, to another hospital? Those records sometimes will be transferred if it's within that network of hospitals, they're going to have access to those files. But if they don't, then your agent is what you would call them, your agent, and you would appoint the primary agent and then someone as a backup and maybe a third party. They would be able to go and get those records and hand carry them to the new facility or to another doctor. So what can they obtain with the HIPAA authorization? They can obtain your medical records. They can also talk to your insurance company and make sure that things are carried out. And if it looks like something's not quite right, they're able then to have those records and look at them. And they can then go out and get the kind of help that you need to make sure that you're taken care of the way you want to be taken care of. Now, I want to talk about what's a living will. What is a living will? A living will is not like your last will and testament, and it's not a pour-over will. Those three items I do want to define during our discussion this morning. So a living will goes along with your healthcare directive. And a living will allows you, the individual, not your spouse, not your children, it allows you as the individual to decide exactly how you want to be handled in the event that you may become terminally ill. And it's not a do not resuscitate order. Let me be clear, it is not. A living will sets out if you want to be put on a respirator. If you don't, it sets out. Let's say you fall and you've had a head injury. A lot of individuals say, I don't want to be resuscitated with that. But what happens if it's merely a bruise on your brain and you're going to recover and become the person that you currently are? You're going to be fine in a number of weeks, right? Your living will would give direction to say, I do want life-sustaining medication or hydration, but maybe just for a short period of time until two physicians that are not related to the physician that's giving the diagnosis of non-recovery, until my family can adequately determine that I'm not going to be the person that I am. I'm going to be in a vegetative state, let's say. I've had some clients to say they don't want to have antibiotics administered in the event of them being unconscious, because if they're not going to be themselves after, they don't want to have their life prolonged only to be suffering later. And so that's what a living will is. And it goes along with your healthcare directive and then your HIPAA, right? Now, let's move on to the next foundation document that everyone needs. A senior needs these documents, and that would be your statutory power of attorney, also known as a durable power of attorney. What is it? It's exactly how it sounds. In Georgia, the state updated the statutory form and requirements in 2018. So my first caution to the listeners is please don't go on the internet and just pull a statutory power of attorney. It may not provide the type of protection that you need. It may not allow your loved ones or you to be able to carry out things in the event you're incapacitated, or if you're just out of town. But let me just be clear about what this statutory power of attorney is and is not. It allows your loved one to carry out any financial responsibilities that you have granted them permission to do. 2, the statutory power of attorney does not exist if you pass away.
Yeah.
It is only valid as long as you're alive and breathing. If you're incapacitated, if you're in the hospital, it's valid.
Right.
And your loved one can go and take care of either the banking, if you have a home, if you let's say you need to sell your home and take those distributions so that you go into an assisted living facility. Mm-hmm. A statutory power of attorney or your durable power of financial power of attorney will allow them to do that. They can take care of that, provided that you've granted them the permission to do it.
Right.
So you would initial next to the authority you want to grant them: banking, real estate, stocks, bonds, investments. And there's another line that you can initial next to, and that is all preceding powers.
Right.
Right? And you want to make sure whoever you are allowing to carry out those duties for you, mm-hmm. that they are trustworthy, that you know that they're going to carry out the duties you want, and they're not going to make themselves comfortable with your finances. But right. Let me be clear. If they do step out of the boundaries that you provide, they are liable. There are penalties, state penalties, for someone doing something that they have no permission to do.
Right.
And you have the authority to revoke whatever authority you've given to them. I've used the word authority several times, and it's because I want to drive home that this is what you're permitting.
Yeah.
It's you that are making the decision, not your children, not your spouse. It's you. So whatever authority you grant them, you can go ahead and revoke that as well. Okay. I've got several anecdotal stories that I could
Let me
share.
jump in, Joy, if I can, because I hear from my residents a lot of questions that come up. Because, you know, being a grandmother and a granddad, we have grandkids, and we tend to move near our grandkids. So we have people coming from Florida, from Vegas, from Iowa, all different places because their grandkids live here. So what would you say, like, you know, when you have, say, some of people have these documents in place, when you move into a different state, what do they need to do to be compliant to, say, Georgia? Is there like specific state legal
yes.
things that they need to be aware of?
Yes. And that's a great question. When my clients, I do have clients that have moved in from the Northeast, from the West Coast. Mm-hmm. Understand those documents standing alone are valid, but in order to execute those documents, if they are residing in Georgia, it's going to be, real estate's going to be overseeing where the property is located, but Georgia law takes precedence.
Okay.
Okay. So I said the statutory power of attorney was updated under Georgia law. Someone may not accept a statutory power of attorney from another state. So you run the risk of that particular power of attorney not being accepted. Right? There's also some transactions. Let's say you want to buy a smaller house, you're downsizing, and you have a power of attorney that you've used for years. That financial institution or that closing attorney may not accept that power of attorney. And so you may have to renegotiate that here in Georgia, and also because of the procedures and policies that institution has. I want to talk about what happens if you're banking and you have a power of attorney that you may have had drafted up in Florida, right? And you go to the bank and you want your agent, also known as your attorney in fact, to be able to do the banking for you. The bank may not accept that. So one of the things that I would say to anyone moving here from a different jurisdiction is to take that power of attorney to the new bank that they have, and they give them a copy of it. I would also say to them, it is worth having a Georgia durable or statutory power of attorney drafted under Georgia law. That way they know that it's going to be correct. But I still would let them know that they need to have their bank have a copy of it so it's on record. I also want to say, don't put those documents in a safe deposit box, because if you become ill or those documents are needed, it's a weekend, it's at night, your loved one does not have a key, or they're not a signatory on that safe deposit box, they're not going to be able to get into it. Now, let's talk about the healthcare directive that I first talked about with you. There is a company that estate planning attorneys will use to allow those documents to be stored at a national organization, right, or company that's been around for more than 30 years. And if a person goes on vacation, they would have a card in their wallet that says that their healthcare directive is on file at this company. And then if they go to a hospital outside of where they live, that healthcare directive would be shared with that hospital or with that doctor. So there are things that can be put in place. But I would say those foundation documents, if they're moving in from another state, need to be looked at. If they own property, real property, then that real property will have to be handled in that jurisdiction. So even if they, and I want to get into what is estate planning, right? Let's start with what everybody knows about, and that's a will, right? Everybody knows about a will. What is a will? A will is your, it's your wishes when you die.
Right.
A will does not handle anything if you're alive, which is why you need your foundation documents in place, right? So who's in control of the will? You might think you are. You can list those individuals that you want to be responsible for you if you pass away, which would be your executor, or for female executives, or the administrator. But the ultimate decision maker for a will is the probate judge.
Right.
And so what happens if you have a will, and it, of course, it needs to be probated, and they present it to the court.
Right.
Several things happen. Depending upon your estate and the person that you've named, generally there is a probate attorney that would handle that, right? And it's called probate administration. Or the person that you've named will have to make an accounting, do what the attorney would generally do with the court. The court looks at the will at the four corners of the document. And if the document has not been altered, written on, then the court will generally deem that it's acceptable.
Right.
But sometimes it may not be. Also, a will can be contested. So if you, in your heart and your desires, are not to leave certain assets to someone in your family because you don't believe that they might take care of them like you would like them to, they might have a drug problem. They may not be able to handle finances very well, and you want to leave it to another person within your family. A will can be contested, and that then will bog down the process. What is the process? It takes anywhere from 6 months to 2 years for a will to be probated.
Wow.
So
Wow.
During that period of time, you're waiting for letters of testamentary to sell your property. Or maybe the court will issue a letter for you to sell the property, but a full accounting must be made to the probate court. And so you, as an individual, you don't have any control over your assets after you die because the probate court does.
Right.
Everything that happens, they need to answer to the court. Additionally, some people say they don't care about this, but I would venture to say it's something that most people do, and that is your will is completely public information, right? So what does that mean? It means that once a will is sent to the probate court, it's published, and everyone and anyone in this community will know about it, and people outside. So there's a lot of unscrupulous people that look to either buy property, undervalue your property, or take advantage of someone that's grieving. So let's first keep that in mind, that probate means that whoever's doing that for you, the loved one that you may have named, they're grieving. And sometimes people that are grieving, they don't think as clearly as they would if they were not going through a difficult situation. And so unscrupulous people might make offers to buy your house, or do any number of things, right?
Let me jump. I just want to jump because a question popped in my mind. When you have the will and then you have somebody that doesn't have I know a person, a family member, that they were called in after the parent passed away. And so it was a surprise at that moment what his intentions were to the kids. So when you say like it's public knowledge, is there a difference between not knowing and somebody that set something up and then the attorney comes in and says, okay, this is how your mom, your dad wanted the assets distributed? Does that mean that, and I got the impression that that was the first time they knew anything of it. When you say public knowledge, is there a difference in that case, like why family members don't know until they sit down with the attorney versus it's published?
Well,
does that make sense?
It does. And you're asking a two-part question. And okay, what I mean by public knowledge is that a will is published, like if you were to sell something, a foreclosure, it goes into the classified ads. A will, when it's probated, is published within the probate court, and that information is disseminated out into the community. Mr. Smith has passed away. His estate is being probated.
So that when that I have seen those in the newspaper. So that's different than the other scenario. Is that
says, is correct.
This is my intentions. I have it in my will, and the attorney sits down with the family and goes, all right, Pete, you get this. Joe, you get this. That those are two different things. One
totally
is
different.
Okay, that makes sense. Okay.
But it goes to, I said a will could be contested.
Okay.
All right. So in the scenario that you're talking about, Pete, at this point, family members sit down and the will is being administered, and to their surprise, their loved one left everything to one other person or more, another asset to someone. That will can be bogged down for years. That loved one is able to contest that will, right? And what do I mean by that? They're able to go to the probate court and say, Your Honor, this is not what I know my mother, father wanted or my uncle wanted, right? I want to make sure that I get what I'm supposed to have. They may have evidence of something different. So a will is absolutely able to be contested, which could drag it out, which
Right.
makes it very, very expensive.
Okay.
And so probate administration generally it's like churning money through, right?
Okay. Okay.
But
That makes sense.
for
So
years,
when you have seniors over here, there's so many things that and I've heard the questions, there's so many things that they don't know when they move in. So do you have like, oops, I think I'm going to sneeze here. Excuse me. So they basically move in, they sell their asset because these are apartments. So they sell their assets and then they move into an apartment. And so they have assets, they have, crossed the state border. So there's a lot of questions they have. Do you like sit down with them just to kind of review everything? Is that the standard thing? Because you don't
absolutely
know, Adam.
Absolutely. And I do want to talk about trust.
Okay.
I'm talking about the instrument of a trust.
Okay.
But I want to also talk about trust that a person must have with making sure that their assets are handled correctly.
Okay.
And so what is my process and what do I recommend, right?
Okay.
First of all, I recommend whatever my client feels is in their best interest, not their children and not their spouses.
Right.
And what is my process? I have my clients or someone that wants to come in and talk to me. I generally will do a complimentary 30-minute meeting with them because I need to hear what they have. I need to hear what they want. And 30 minutes will give me a general idea.
Okay.
And then if they want to proceed, if they've moved in and they've sold their assets or they still have assets that are in a different state in children, there is a very detailed questionnaire that I go through with my client.
Okay.
I don't just give them this and say, go figure this out.
Right.
We sit down together and I want them to feel comfortable with sharing with me exactly how they want things to be handled if they can't speak for themselves or if they pass away. Okay. After that meeting, that's an hour's meeting. Okay. I ask them to come back after they filled in the questionnaire. There might be account numbers they don't know. Okay. They may want to think about who they've always thought would be good for a healthcare directive or for handling things if they die. But I want them to think about it and come back in a week or so. They may want to talk to someone about being that agent or that a successor trustee or whatever. They come back and then we fill in those blanks. From there, I begin a process of just sort of drilling down even further. Right. And we have a third meeting, and that's a shorter meeting. It could be done over the phone. It could be via Zoom, right? Okay. And generally it's a 3 to 5 page document. And I go through everything we've already talked about, but I want to make sure what they want. Names are spelled correctly, addresses are correct, phone numbers are correct. They may have changed their mind. And then from there, I will draft their final documents for them, right? Okay. Now let's step back a bit because Pete, you asked me what happens if they've sold their assets and what have you, and they're in one of, let's say, an apartment or an assisted living facility or an over 55 community. They're completely on their own, but they still have appreciable assets or tangible assets, and maybe not. Maybe they sold a bunch, or maybe, heavens forbid, they have what's called POD or payable upon death, right? Okay. On some of their accounts for their children. So if they do have those kinds of designations, or if they have real property and they have a joint tenant with right of survivorship with their children's name on it, we talk about, one, the tax ramifications of that and the liability exposure that they have
Right.
by doing that, right? Because if you have an account that's payable on death to an individual, or you have them listed as a joint owner on the account, you also face whether or not a creditor can attach that account because their name is on it.
Right.
You don't want that. That's your account, right?
Right.
If a home has joint tenant of right of survivorship to a child, I've had several nightmares. One, an adult male, did not tell the parent that he had child support that he was behind on. What happened? The state came in because child support is controlled federally across state lines. They came in and placed a lien on the property for legal fees as well as the total amount of child support. So the parents did not have that property any longer. Or you might have someone that's a loved one that's not very nice, and they end up just wanting the property.
Right.
And if you need to sell that property, real property, so that you can pay for your living expenses, you're not going to be able to do that if they don't sign. So what do I generally recommend? I do recommend that individuals consider a trust document.
Right.
And the reason I recommend that is twofold. One, it's not public record.
Right.
Two, you are in control, not the probate court.
Right.
You name who you want to act on your behalf, both while you're alive and when you pass away. Now, just keep in mind, we talked about a will does not handle anything if you're alive.
Right.
Right? A trust does. A will only handles things if you do pass away. A trust does as well. But the court does not oversee that. So what's involved with the trust?
Why don't we do this, Joy? Because I'll tell you this, it's more complicated than I ever thought. You know, it's funny that we think it's easy for us to not think of things and just kind of like put it off in the corner and go, hey, we're not going to die. But we are. We all have an expiration date. But so why don't we do this? Because it is you've been enlightening to let our viewers know there's more than just get a will together. Those, some of them have, and even a percentage doesn't even have that. What would you say? Give our viewers like how do they get a hold of you, a contact, so they can get a hold of you? Because I know they're probably thinking, I have this thing, this thing, this thing, and they're going to want to get these addressed because you've educated our viewers on there's more to it than we even think. And it's moving across state lines. If I've heard it once, I've heard it 5 times. What do you know somebody, or, how do I do this? And of course, I'm not an attorney. So I don't even play one on TV. So give our people, how do they get a hold of you and a good place to contact you?
Absolutely.
Mm-hmm.
My phone number, I'll give the phone number first, okay? My phone number is 770 627 5520. The name of my law firm, if you misplace the phone number, is Green-Armstrong, just like the color. Green-Armstrong, attorney at law.
Okay.
I'm located here in Kennesaw, Georgia. The address here is 1350 Wooten Lake Road.
Mm-hmm.
And I'm in Suite 101, and my building is 100. And I'd like to say that my office is accessible, ADA accessible. So if someone has some limitations in terms of stairs, my office is on the first floor, and
awesome.
I have an entry
You're speaking to our seniors. We have rollators, we have wheelchairs, we have things. Because when I moved in here, it was 55 and older, but I soon found out the average age was 78. So it was a little bit north of 55. And you just look around, you can see that, you know, they've gotten up there in age.
That's
so
right.
What we'll do, we always because you've given us a lot of good things to understand. And I think as a person that, you know, doesn't know anything about the whole legal process, it's important to do your due diligence before it happens. Because I did run into a person, he was saying, yeah, I'm going through probate, and, you know, and it was like, oh yeah, you know, it's not a pretty thing when something like that happens, because just what you said, it's so, you know, what is it, 6 months to 2 years or something? Is that what
Correct.
I hear?
The other thing, you're so right.
Yeah.
In terms of a lot of information. And for some individuals, it might feel like they're drinking water from a fire hose, but it's really not. If a person sits down, it can be understood in bits and pieces.
Gotcha.
I would just say to your listeners, you're right when you say don't wait. Just briefly, 2 clients came in for a spouse that had a disability or was ill. And I ended up with my paralegal going to intensive care for the person that was the caregiver.
Okay.
That needed to have those documents signed.
Right.
And so to wait, we're all human. Nobody wants to think about their mortality. Yes. But it doesn't necessarily mean you're going to die. It's putting things in place so that you can live the way you want, and not have someone go to the probate court and have a guardian assigned to you. Yes. So I'll leave you with that.
Yeah, and it's so important. Yeah, I've heard it. You know, you're thinking of your kids. Do you want them to have to go through all this complicated maze of, you know, they're already dealing with the loss. Now they're having to deal with, you know, a maze of decisions that they didn't necessarily want, because we as seniors didn't prepare them for, you know, be able to make that transition. So we always let our guests do this, Joy, is what would you like us to remember you, like not your closing statement. No, you're just an insight that you can share with our viewers before we wind down.
I would like to share with the viewers and your listeners that they are in absolute control. Right. That I don't want any of them to feel that they can't choose to have things done just like they want them done. Right. That to have the state of Georgia or any other state make a decision for you is not acceptable, nor is it acceptable for someone in your family or a friend to make that. Take control of your life. It's not, it might seem daunting, but it's really not. If you have someone to help you walk through the process, then you can rest easy. It's done right.
Awesome. That's really good to leave our listeners with that, because we love our loved ones, and we want to make sure we do the necessary steps to make sure it's as easy, not easy, but not as complicated as it can get without necessary knowledge of the legal rights.
Right.
So I want to thank you, Joy. We'll put, for our viewers, we're going to put all your links and information in the show notes. So if you're driving down the road, you don't have to worry about it. We'll make it easy for our viewers to get a hold of you. And I want to thank you for, taking the time to share with our senior community just things they need to be thinking about.
It has been my pleasure. Thank you.
You're welcome, Joy.